Hello, I'm Nancy Hay, mother of Sabrina, who is now 4 years old. She has been in foster care for all but the first 3 weeks of her life. She was abducted from us by CPS after Dr. Michael James Sheehan at Virginia Hospital Center falsely accused me of starving her and of being mentally incompetent of raising her, simply because she lost a few ounces after birth and was slow to regain her birth weight because I was breastfeeding her. Sabrina had been diagnosed on entry to Virginia Hospital Center, hereafter referred to as VHC, with failure to thrive. However, the only reason for her slow weight gain was that her pediatrician, Dr. Eli Mashauer, had simply given me inaccurate advice on how much to supplement the breastfeedings with baby formula. The problem was resolved while she was in VHC, as well as after she was released, simply because the amount of formula had been doubled. Before our release from VHC, Dana Zemke, a social worker from the Arlington County Child Protective Services, compelled my husband and me under duress to sign a safety plan, saying that a refusal to sign would prevent Sabrina from being discharged. This plan only said that we would allow home health care nurses to visit our home, but required nothing about agreeing to let Ms. Zemke enter our home. However, Ms. Zemke did, in fact, keep coming to our house every day after discharge from the hospital to conduct a hostile investigation of us. When we gave her a letter stating that we wanted a time out while we retained legal counsel, she retaliated against us by going before Judge Esther Wiggins-Lyle of Arlington Juvenile and Domestic Relations Court and getting an emergency removal order. Sabrina was then placed with an unrelated couple who had political connections and who had stated from the beginning that they wanted to adopt Sabrina. The initial charge of neglect was overturned on June 21st, 2006, by a hearing officer designated by the Virginia Department of Social Services. Despite this ruling, CPS continued to argue vigorously for the termination of our parental rights with Judge Esther Wiggins-Lyle and later with Judge James Almond of the Fourth Circuit Court. They had continuously shown a prejudice against me because I had been diagnosed with a mild learning disability, pervasive developmental disability, which is a mild form of autism. On June 1st, 2007, Judge Almond upheld their decision to terminate our rights. He showed his prejudice against parents with disabilities, stating that my difficulty in reading nonverbal cues was a major reason why I was unfit to raise Sabrina. He alleged that this difficulty caused Sabrina to be hospitalized for failure to thrive by preventing me from instinctively knowing that I should feed her more formula than what her pediatrician recommended. He also allowed Sabrina's foster parents to move out of state with her. After Judge Almond's ruling, CPS tried to get a gag order against my husband and me to prevent us from publicizing our case and CPS's wrongdoing against us on the internet, claiming that we were violating the privacy and safety of Sabrina and her foster parents. This was blatantly unconstitutional. Eventually, a compromise was reached whereby we could publish information provided that we omitted Sabrina's last name and the names and location of her foster parents. This was ironic since Only 6 months in foster care, the foster family themselves had shown themselves and Sabrina on TV and on YouTube using their own names in an interview about their home renovation. There were multiple indicators that right from the beginning, CPS had no intention of returning Sabrina to us and had promised her to her foster parents. Only 6 months along, the foster family showed a video to Judge Wiggins-Lyle in which the foster mother referred to herself, to Sabrina, as Mommy, and in which relatives told Sabrina that they would show the video to her on Sabrina's wedding day. Judge Esther Wiggins-Lyle condoned this behavior. There was also a conversation between CPS Supervisor Kevin Daly and our lawyer Carl Cohen, in which Mr. Daly said that he thought Sabrina's foster parents, quote, would make excellent adoptive parents in the event of a termination of parental rights, unquote. Unfortunately, the Virginia Court of Appeals and the Virginia Supreme Court also upheld the lower court's decisions. Judge Robert J. Humphreys of the Virginia Court of Appeals refused to acknowledge that I had been discriminated against. He stated that he thought it was in Sabrina's best interest to be adopted by her foster parents because, as he claimed, my PDD-NOS diagnosis prevented me from adequately responding to a child's needs. Parenting one's own child is a constitutional right. Nowhere does it say that people with disabilities do not also have this right. The truth is, all of the judges wanted to circle the wagons so as to avoid dealing with the greater issue of corruption inside Child Protective Services. Sabrina's foster parents had political connections and were therefore favored by CPS over my husband and myself. The foster father is an assistant U.S. prosecutor for the Department of Justice, prosecuting cases of domestic violence. They both knew Arlington County Supervisor Paul Ferguson, who gave them a favorable assessment on their property in Arlington, helped fund their home renovation there, and happens to now serve as a clerk in the court in which James Allman serves. Unfortunately, we have not been allowed to see Sabrina for the last 2 years. Her foster parents refused to give her the gifts we sent her for her 4th birthday and returned the package to us unopened. In conclusion, here are some photographs of us with Sabrina back during the time we did have visitation rights with her.